We all want to achieve our financial goals, but sometimes we're not sure how to reach them. We are here to help put you on the path to financial success so you can get where you want to be. Our holistic approach gives you a better look into your finances so you can invest, save, and pay down debt intelligently. We help you plan for retirement.
Hello, I'm Gaitan with Dreamcap Financial. So let's dive right into the essentials you need to know about estate planning. So if you had to deal with someone's affairs after they pass, I think you'll agree that it's one of the hardest things we can go through, especially if there's no plan in place. So you're not only grieving, but you're having to deal with so much logistics, with conflicts, with costs, and so on. So today I hope to share with you some strategies that's not only going to help you minimize the costs in your estate, but also help provide and care for the ones that matter the most to you. So for today's webinar, we're going to use a hypothetical example, and we're going to call them John and Jane. So John has two children from a previous marriage with me, and John later marries Jane, and they have two children together. And combined, they have an estimated assets of $2 million. So the amount here, by the way, doesn't matter. It's just going to help make the math a little easier as we move forward. So whether it's $200,000, $20 million, the concepts are going to remain pretty much the same. Let's first explain what probate is. It's basically the process of settling an estate in front of a judge. So in case of death, they take your estate, you go in front of a judge. Now, when you're in probate, okay, who are involved in probate? You have your heirs, your beneficiaries, right? You have the judges that are involved in probate, and you have attorneys that are involved in probates. Do attorneys work for free? No, they don't. It's very expensive. So you have to cover attorney fees, court fees. Second of all, as I just mentioned, it takes a long time. The information in probate is public. So if you go on Miami-Dade records, you'll be able to see exactly what the estate constituted of and all the results and all the beneficiaries because it's all public records. A lot of family conflicts results out of probate. It's very stressful on the heirs, and a lot of time they're fighting for inheritance. So these are all the obstacles that we face when we go through probate. So the questions we ask are, do you have a will? Do you have a trust? Do you have a power of attorney? Do you have HIPAA waivers? And if you answered yes to any of these, other important question is, when's the last time you reviewed it? We met somebody last week that had a will for over 20 years. So her wishes has completely changed now. So it needs to be updated. Sometime we may have beneficiaries on our will that are no longer with us. So again, they might need to be updated. Okay, so what are some of the goals we may have when we do estate planning? So those goals include making sure you pass your assets to your beneficiaries in the manners that you really want. And we try to avoid or minimize unnecessary taxes and costs when we do estate planning. And we avoid misunderstandings. So as I mentioned earlier, when we're in probate, there's a lot of family conflict because if you don't lay out exactly how you wanted your assets to be passed on, then your heirs are forced to assume, based on their relationship with you or their mindset, how they would want those assets to be passed on. So, what are special circumstances? So, there are special cases. For example, if John and Jane have a disabled kid, then there might be special circumstances that we need to include in the trust. You can designate certain conditions or designate somebody to properly care for that person. So there are special circumstances. Another one would be, let's say John and Jane have a son that's on their third marriage and they don't trust that third wife. They're like, oh my God, little John's been married 3 times already. And what happens usually when you go through a divorce? What happens is that you split everything 50-50, unless there's a prenuptial agreement, but that's a topic for another day. So all these can be accounted for when you do your estate planning properly. Why should you have an estate plan? So it's to really keep control, have control, designate control on how you want to transfer your assets to your beneficiaries. Okay. And when you have a trust, and we'll go over the different titles and the different individuals that are involved in the trust, but no pun intended here, is you designate somebody that you trust when you're drafting your trust. And going back a little bit on the special circumstances, if any of you have minor children as well, then you want to have special sections in your trust indicating who you want the guardian to be and what the conditions are. Maybe you want to give an income since that person is now gonna care for your children. You want to compensate them a certain way so they can again manage your estate for you and care for your children if something were to happen to you. So what's included in your estate? Basically everything you own is included in your estate, whether it's properties, whether it's a bank account, retirement accounts, life insurance. If you own any art collection, jewelry collection, all of that make up your estate. And you will designate how you want those assets to pass to your beneficiaries. So now let's go into the legal documents that make up your estate plan. So, first, we talked about why having one, what are the goals we might have in drafting an estate plan. The next step really is to draft the documents that you need and how they work. So, it's going to address exactly how to disposition your assets legally to your heirs. And also, and this is an interesting conversation that occurs pretty often. I do meet with people that tell me, hey, to be honest with you, Guyton, if I were to pass away, I don't care what happens. I'll be dead anyways. That's your choice. And we support your goals, right? However, a lot of times people fail to realize that estate planning is not just in case of death. In case we become mentally ill, incapacitated, then who do we want to make decisions for us? Who do we want to give access to our financials and all our private affairs? So that's also a big factor of estate planning. So which plan do you have? So of the government plan. So that's the plan that's designed by the government to handle your estate. So there is a plan, it's just not one that you have control over. Now, there is your own plan, and I'll share strategies with you where you can build your own plan. So let's walk through it. So, first of all, the government plan. The government plan is probate. So, we talked about probate, we talked about some of the obstacles of probate. So, we talked about probate being the process of settling an estate in front of a judge. And we talked about how it's costly, it takes time, it creates stress in the family. So if we go through probate, which is the government plan, your assets number one is frozen. A lot of people don't realize that. So if John and Jane pass, as the example we used earlier, and they did not have a plan, any estate planning, they would go through probate. So let's say they had the $2 million that we talked about, and in various instruments, some of them might be in checking savings accounts, some of them might be in 401k, IRAs, some of them might be in properties, a combination of everything. All those assets will be frozen. The beneficiaries cannot have access to those assets until they go through probate. Now, there are certain exceptions, which I'll go over a little later, such as IRAs. They're called beneficiary designated accounts. But all your other assets that don't have a beneficiary will go through probate, and the assets will be frozen. So you'll have to hire an attorney. The court is in charge. If you don't even have a will, then the judge will be forced to make decisions. One example that always comes to mind, because he's a celebrity figure, and he had a huge estate, and that individual is Prince, the musician. He did not have a will, he did not have a trust. It took over 6 years to settle his estate. All his information was public because it was public records. So, not to throw him on the bus, but I just thought that was a good example people could relate to. Now, the other alternative is to have a revocable living trust. So, revocable living trust, number one, is when if you do decide to draft a trust, you want it to be revocable. Why? So you can make changes. There are also what's called irrevocable trusts. We're not really going to get into that into detail, but I will address them a little later. So if you have a trust, your assets are not frozen. You could start distributing assets immediately with the death certificate, and your heirs can avoid the probate process. And lastly, it's private. Revocable living trust remains private. It does not go through probate, does not go through the trust to the courts rather, so it stays private. And if you have a will, it does a big portion of the estate planning. And that's that it you get to choose who you beneficiary. So it still goes through probate, but however, the judge is no longer going to make the decisions for you because you already stipulated who you wanted to have your assets. So, what are the disadvantages and advantages of a will? So, again, as I just mentioned, you get to designate who you want your beneficiaries, you get to designate who gets what. The disadvantages is that you still go through probate. What I want you guys to remember is if all you have is a will, you will go through probate. So trusts are arrangements that allow a third party, a trustee. So let's go a little bit more in detail on how the trust works. So here are the key roles involved in a trust. So using John and Jane as our example again earlier, if John and Jane decide they want to draft a trust to protect their legacy, they will be the grantors of the trust. So they're the ones drafting, initiating, and putting their assets into the name of the trust. They will also typically be the trustees. The trustee is the person responsible for administering the trust. And also, they can make decisions into the trust. And then you'll nominate, John and Jane being the grantors and the trustee, will nominate who they want their beneficiaries to be. But they'll also nominate who they want a successor trustee to be. Once they pass, they will have somebody, as we mentioned earlier, that you trust to be now responsible for administering your wishes into the trust. So these are the key roles involved into a trust. So is a trust right for you? So there are instances where I meet with clients where I tell them, for your particular situation, you don't need a trust. I'm not saying everybody should have a trust, but it's a great instrument for you, especially if you have minors, if you have properties. It's a great way for you to get your wishes granted. So the advantages of a trust is you gain control, you keep control, and your generation, your legacy will have control over your assets. The disadvantages, it is very costly to do a trust. So we ran a survey last week in Nova, and just to get a gauge, I mean, we know the answer, but we always like to get a feel for what people got quoted or what they paid for a trust. And the answer is typically 3,000, 4,000, and we heard last week as high as $10,000 to draft a trust. So it can be expensive. So how does the trust really avoid probate? You might be wondering. So again, if John and Jane has a trust, their assets now are gonna be named into the trust. So if I go on miami-dade.gov, if I look up your property address, it will show your name as the owner and beneficiary of that house. That means automatically that house will have to go through probate. If John and Jane draft the trust, now if we go on miamidade.gov again and put their address on, it will reflect the name of the trust. And that's how it bypasses, because the trust will not be dead. The trust will continue to go on and bypass probate. It will just distribute to your heirs. So that's how it avoids probate. I want to bring in another very important aspect when it comes to the trust, and that one is funding the trust. So funding the trust means naming your assets into the trust. Let me share some examples. So if you go ahead and pay the two, three, four, five, $10,000, whatever the attorneys are charging you to draft the trust, and you fail to fund the trust, which means naming your assets into the trust, then those assets are still going to go through probate. So it's as if you went to Home Depot and you go and buy this safe. Hey, I want to protect my jewelry and all my belongings. I'm going to buy this highly secured safe and put my belongings, and you bring it home, you leave it in the closet, and you never put your belonging into it. So in essence, you just bought a safe, but really didn't protect anything. For most of you here, you will need a revocable trust. Very few people we meet will need an irrevocable trust. So, for example, there is a loophole in the system where you guys familiar with Medicare, Medicaid, right? So Medicare, for those that are not familiar, Medicare does not cover long-term care. So what is long-term care? Long-term care is if you have a condition where there's certain things you can't do on your by yourself, like eating, bathing, and so on, then you will need prolonged care to assist. So people sometimes with that are mentally ill, incapacitated, will need long-term care. But Medicare does not cover that. They cover only 100 days. After that, you're on your own. Medicaid, on the other hand, does cover long term care. However, as some or most of you might know, to get Medicaid, you can't basically have any assets. If you have more than $2,000 in assets, you don't qualify for Medicaid. So there's a loophole in the system that could be used where you would put all your assets into an irrevocable living trust, where basically you're transferring now those assets outside of your name to another beneficiary and a trust. So now the problem with an irrevocable trust is that, again, the word here, irrevocable, you cannot make changes. So if you ever change your mind, sorry, too bad, too late. You can't make changes to an irrevocable trust. So there are, again, special circumstances where it might make sense to do an irrevocable trust. But for most people, again, when it comes to probate, making sure your wishes are granted, a revocable trust will be the way to go. So other options to avoid probate, you have your beneficiary designated assets. So there are certain accounts that some of us have, or most of us have, that where they ask you to nominate a beneficiary. Now, I do hope that you guys took the time to do it correctly. But the beneficiaries now, if for example on the 401k, it asks you for a beneficiary, and a life insurance, it will ask you for a beneficiary. So those will avoid probate. If all you have, if your main assets is only a property, and that's what you want to leave for your heirs, then a ladybird deed might do the job. Instead of buying, paying all that money for a trust, you could just do a ladybird deed, which is much less expensive, and accomplish the avoidance of probate with that. And finally, with your bank accounts, there's also the TOD, POD. These mean transferable on death, transfer on death, and payable on death. So if you have a bank account and you happen to keep a large sum in your checking, savings account, or whatever the sum really, you can avoid probate with those accounts as well by having a TOD and POD. So these are some maybe less expensive options that are available to you. So beneficiary designated assets will avoid probate. You get to designate your primary and contingent beneficiaries. The disadvantage is it's a direct transfer, number one. With the trust, for example, you can, let's say you have an 18-year-old, just became an adult, so now he's legitimately eligible to receive your assets, but you don't quite trust him yet. He's 18 years old. You can have a stipulation in your trust stating, hey, we want him to have 25% at 18, another 25% at 25, and the rest at 30. So all those you can designate with a trust with the, again, beneficiary designate assets such as your 401k. It's a direct transfer. They're going to get 100% automatically. All right. Hope that makes sense. And moving on. So power of attorney. So as I mentioned earlier, your estate plan is not only for when you are deceased. While we're alive, there are situations, and we all know somebody where something happened and become incapacitated. And so what do you think happens, for example, going back to John and Jane again, if John becomes mentally ill and he has an IRA account, that's where all of his money is, and his wife Jane needs to pay his medical bills, needs to pay the mortgage, and he has most of his money in the 401k. Can Jane go in the account and get money out of his account? No, she can't. So that's where a power of attorney comes in handy. So you grant somebody of trust power if something were to happen to you where you're not deceased, where somebody can have access to bank accounts, where somebody can have access to your IRA, pay your bills, call the mortgage company, pay property taxes, you name it. And healthcare directives, also known as a healthcare power of attorney, is who do you want to make medical decisions for you if you're in the hospital and if you're in a situation where you're not able to make your own medical decisions. So sometimes those individuals might be different. So you might have a brother that's a financial advisor, and you trust them with all your financial matters, and you're like, you know what, he would be the perfect person to handle my financial matters. And you might have a sister who's a doctor or a nurse practitioner, and you trust that individual, on the other hand, to make your healthcare decisions. So they could be different individuals. So estate administration is basically, now we're settling the estate, and now you have to pay creditors. If there's any taxes associated, you have to pay the taxes, and then we distribute the assets to your beneficiaries as you wished. And if you failed to fund your trust, if you did have a trust, any assets that did not have beneficiaries will be probated. So, can probate be avoided? So, yes, probate can be avoided with proper advanced planning. So, if you don't have a will, you don't have a trust, basically you're in the government's hand. They will make all the decisions for your estate. If you have a will, at least the judge will grant your wishes unless there's any contest to the will, but that's another story for another day. And if you have a revocable trust, you will not only grant your wishes, but you will also avoid the probate process. And again, as I mentioned earlier, if all you have is a will, you will go through probate planning with them. So estate planning is your legacy. It's really taking care of your family. Family is really important to us. And if it is important to you as well, we want to make sure we address that.
I like to understand who you are, who matters to you, what are your objectives, what do you want to accomplish. We're called DreamCap Financial, but the reality is everybody has a dream. They have a financial dream. To help you achieve those goals and those dreams is really understanding who you are, what you want to become, who matters to you, what do we want to do for them.